Welcome, everyone. We're doing the best that we can with what we have, and so this is the time and place that we tried to get together a little Zoom conference with family law lawyers. I appreciate we have many people on the Zoom call. I appreciate that. I don't know, we also have this available on a YouTube channel, and I don't know how many people are attending that way. Mr. Shaw is continuing to try to let people in and admit people, so I really appreciate everyone. I encourage anyone that has any questions to submit them. We have a chat feature on Zoom. We also have, you can send them to my email. I can pull that up without causing any upset either. With the agreement, I guess, of my fellow judicial officers, I think it's important and to recognize life events. We all are living through this pandemic, which is what this is all about, but we've also all been living through protests and recognition of the systemic problems that we have with racism in our nation. And in law school, I hated the idea that we just got on a bus and were delivered from one place to the other and pretended that life didn't happen around us. And so it's important to me that that's not who I am, and that's not who we want to be. So we want to recognize George Floyd died. He died on my birthday, May 25th. And that has highlighted for all of us a long, well-documented struggle for justice with people of color and with policing and ways to make sure that we are exercising the police power with the rights that our country promises in mind. Those are immutable facts, as is the idea that our government is a social contract. We are here because we agree to be here, and the people in power are there because we agree to cede that power to them. And we as judicial officers recognize the awesome power that we have been given and that we exercise daily. And as judicial officers, we appreciate and recognize the obligation that we all have to make that contract better and stronger every day through judicial reform, through police reform, through criminal justice reform. And we pledge to you our continued efforts, best efforts. We want you to know that this is a difficult time, and we are using our best efforts every day in the continued effort to find justice for all. And for those of you that haven't read it, I commend to you, members of the Spokane County Bar just received this from your Bar Association, from our Bar Association, the open letter to the legal community from the Supreme Court. And it's signed by all of our justices. And I just want to read a piece of it that says, the legal community must recognize that we all bear responsibility for this ongoing injustice, and that we are capable of taking steps to address it if only we have the courage and the will. The injustice still plaguing our country has its roots in the individual and collective actions of many, and it cannot be addressed without the individual and collective actions of us all. And it finishes by recognizing on behalf of the Supreme Court that they go by the title of justice, and by this letter reaffirm the deepest level of commitment to achieving justice by ending racism. They and we, as judicial officers in Spokane County, urge you to join us in these efforts. I believe it is our moral imperative. Now, hopefully, on to lighter things. This is a family law court conversation. Our Superior Court judicial officers, our commissioners, our judges, invite everyone to participate. And first of all, we want to talk about, we're going to kind of reflect and say, what have we learned as we've gone through this process? And I guess I'll first invite Judge Belfingren to speak, and then we'll, as soon as that's done, we'll recognize Commissioner Ressa, and she'll have a conversation as well, and then we'll have some time for questions or answers. This is one of the issues that I find is most difficult with Zoom, is that the person at the microphone has to sort of take control, because we've got to make sure that everybody has an opportunity, otherwise we're jumping on each other. Probably rude of me to say, but I like to have in-person hearings, because when I interrupt you, then you know you've been interrupted. So with that, Ms. Judge Belfingren.
Okay, thank you. Yes, Commissioner Ressa and I are going to talk about what
We've lost audio.
No, we've lost it completely.
Could you hear better before?
We could hear Judge Finney. I can hear someone now.
Oh. Can it hear you at all? Any of them? Shake your head. So see this microphone.
I could hear Jonathan and Ann.
Are you able to hear me at this point?
Yes.
Okay. So I was using the wrong microphone. So Commissioner Ressa and I are going to talk about what we've learned. My comments are going to be brief. I'll be starting the family law docket in July. And my intention is to make it a seamless transition. I'll be taking over Judge Fennessy's cases, and I don't want there to have to be a huge adjustment for the bar, adjusting to a new judicial officer. So I do hope that it's a seamless transition. But just to speak a little bit about what we've learned, I think it's obvious to everyone that we've learned that the court system has not really kept up with technology. And that's, I guess, a benefit to this pandemic is it's really forced us to utilize the technology that is available to us. And I'm so happy to see multiple people choosing to participate via the Zoom platform this afternoon. Many of us participated or were present for the webinar where Chief Justice Stevens and Judge McKay talked about COVID and the courts. And something really struck me that Justice Stevens said. She said that we really need to address access to adequate technology and also redesign how you practice law. So I think one aspect of that is being open and just to the option of using Zoom for our hearings. I think most of your clients have smartphones, they have laptops, and it's my personal opinion that the Zoom and the remote hearings are really an access to justice issue. It furthers access to justice for individuals, and it makes participation in the court hearings very easy for them. I also recognize that by human nature, we are adverse to change, and it's not necessarily comfortable to make a huge change. But if we look at our personal experiences, we know that oftentimes there's just a great benefit that comes from stretching ourselves. So I know there's probably some hesitancy for utilizing Zoom in a court hearing, but I would just urge you to try it. Encourage your clients that there is no, or reassure them that they're not going to be treated any differently if they appear in a remote setting. Also, maybe others will talk about this more, but I just wanted to add that I think there could be a concern that if you are participating but via Zoom and your client is, that it'd be difficult for you to have a conversation with them. But we do have chat rooms. I know the commissioners have been utilizing that. Also, another thing to consider is having your clients participate with you in a conference room via Zoom. That would mean 2 people together as opposed to multiple people in a courtroom, which is much more difficult to manage social distancing when everybody shows up in the courtroom. So that's pretty much all I wanted to say, is that I think what we really learned is that we're not using technology to the extent that we could be, and I urge us all to be open to that and to explore that. Commissioner Ressa.
Right, good afternoon. I'm coming to you live from my office that I can, thanks to Zoom, immediately and seamlessly switch to my courtroom and back if I chose to. I really am pleased that as many of you have appeared today that are participating, because we know we need to be able to communicate with you in a way that's effective and efficient and doesn't create so much chaos. If you can get back to just for 1 second to the mindset of March 20th, or that time period of what was happening in your world and happening in ours. So I want to talk about what reflection is, and then we'll move on to what next steps are. So reflection is, well, it's a lot of things, but one definition is that it's a serious thought or consideration. Reflections give the brain an opportunity to pause amidst the chaos. So we'll talk about what happened there at that pause. Untangle and sort through observations and experiences, and consider the multiple and possible interpretations and create meaning. And I never believed that I would be living in unprecedented times. That was for my grandparents in Great Depressions and Great Wars. And the stories they were able to share about what it was like to live in that time, I never expected to be part of my own life. And we are living in unprecedented times, and we will be talking about this for the rest of our lives and for generations to come. And I believe that we are all given this life because we were strong enough to live it and live through it. And what I watched in the shutdown of the end of March, at least in our county, what I watched were 20 thoughtful people in their own way and with their own unique style and skill, trying to figure out how to keep working. We didn't have those kinds of plans in place that I think we will after this, that could communicate through systems. So we, the stakeholders, the lawyers, the courts, service providers, we went our separate ways. And then we were in conflict because we were not able to communicate what was happening with each of us. Not because we weren't all concerned about the same things. I watched that we had individual and personal responses to crisis and chaos and stressors that are very, very different than anything else we've had to deal with as judicial officers. Often we're dealing with crisis in our professional world. And so we can manage those crises in the ways that we've been taught to do so, or that we have experience with. This touched everyone's personal world as well, whether it was something about having kids at home and no school, elderly parents with health issues, maybe it was your own health issues, maybe a spouse or family with health issues that were going to be impacted. We all had a personal and professional impact from this virus, which is not something we've had to experience before. We all have different styles of leadership, whether it's authoritarian or democratic or visionary or affiliative or humble or transformative. We aren't necessarily trained leaders, but we all have different styles. We all have different communication styles. We communicate assertively. Some of us communicate passively. Some of us communicate aggressively. Some of us do all three or passive aggressive at the same time. We have different communication styles. And when you're in stress, that style is often not the most thoughtful. Our relationships were tested, some were damaged, most were repaired. But I watched people try to do their best in what was not something that any of us could have planned for. So what did we learn to untangle and sort through observations and experiences in this reflection? So we learned that some jurisdictions were prepared for this throughout the country. So post 9/11 and post Hurricane Katrina, there were courts that had already been impacted by significant crises in their communities where they had to plan differently. I learned for the first time at the middle of April that there was a pandemic and emergency response task force by the National Center of State Courts that had a report from 2017. Not something that I don't know if all of us knew about, but once we did, we were able to have a better roadmap of what we needed to address. We got to watch other states do things before us. California had their shelter in place a week before we did. It was difficult to use necessarily what other jurisdictions were doing around the country because we all are so different, whether it was a decentralized court or a centralized court, whether courts had e-filing already. Many courts around the country were already doing remote hearings before COVID, so there wasn't quite the same disruption. We learned that we couldn't even necessarily compare and contrast and just repeat what we were doing in other counties in the state of Washington because our systems are so different and the way we do business is so different. We learned, as Judge Belkengren said, that we have agent technology. We have a wide variance in comfort level with that technology. I certainly learned that, certainly advantageous to not have a hairstyle because then when you can't get your hair cut, it's lots easier to manage. I learned that when I first started texting my dad, and he didn't ever want to text me because it was such a odd way of communicating, and watching him over the years text more and more and more, that it felt like that to me. The first time we sent emails back in the mid-90s instead of phone calls, all this new way of trying to get comfortable with something that's new and different, since many of us really like to look like we know what we're doing and that we have the answers. I contrasted us with the boards that I sit on with private business who have so much more flexibility than governments do as far as when they can purchase things and how. People get their master's degree in training in crisis management and change management. That's not who we are. And we have all had to gain skills in those areas that people spend years learning how to do while we were in crisis and while we were dealing with other people in crisis. So what do I hope to see? I hope to see that we take such an opportunity to transform a system that was never created for families. It was never, families just got put into court systems that were established well before many of the people on this call even got to have a say in what was going on in courts. I've seen us remove barriers for people. They don't have to figure out parking. They don't have to figure out childcare. They are not missing a whole day's work for a 15-minute hearing. They don't have to get bus fare. They don't have to be exposed to their abusive partner or an abusive lawyer. They just have different access than they used to. So my hope is this, that we never really go back to exactly what we had before. I believe people underestimate their capacity for change. And I also believe there's never a right time to do a difficult thing. But can we, as we create a new way of doing business, ask ourselves each time we decide to a practice or a policy, who does this work for? Does it work for the judges and commissioners? Does it work for the lawyers? Does it work for the families? And do we have all procedures and practices in family law that work for families as our first priority? My hope, because I saw so many of you doing this, that lawyers continue to do the lawyering. They are the counselors at law. They give the options. They remind their clients of how a court hearing is not likely to improve any relationships, and that courts can decide legal issues, not parent other people's children. And finally, my hope is that I want us to all stay curious and keep learning from this, because as Maya Angelou said, when we know better, we do better. And I think we can do better for our families. Thanks, Judge.
Thank you, Commissioner. Now I'm going to turn the microphone over to Commissioner Swenomson. It might be easier if you go to the podium for the phone. For the phone? It's actually the phone connection, though, because we're running, yeah.
This one, yeah.
Yep.
All right. Hello, everyone. Good to see you. I can't remember what Mr.
We're muted.
Level with me. I'm muted.
Go ahead.
Can you hear me now?
Yes.
Wow, I've never been so quiet before. All right. I'm here to talk about, I will start over. I was one of the commissioners that stayed on campus the entire time. We had a few of us that stayed on. A lot were at home doing remote hearings. We had a lot of civil commitment hearings that were still going on and other hearings that we figured out fairly quickly how to do remote hearings. I think what we learned, to just backstep a minute, is we learned lack of communication, and we need to learn how to communicate better with the different bars, because we would often hear third hand that a lot of attorneys and practitioners thought we weren't hearing a lot of matters, that in fact I just had a full docket of 8 hearings that day hearing exactly that. So I'm just going to talk about what we were hearing during this time, at least on campus. The dockets looked different as we tried to figure out how to do dockets without docket calls. As everyone knows, we have a lot of dockets where we bring a large amount of people into a small room and then figure out what we're going to do from there. So as we started to figure out how we were going to schedule them specifically and not bring everyone down, naturally that reduced the amount of hearings we could do. And so we reduced our dockets of family law to 2 full days a week. We did 8 hearings on each of those days, and we did limit what we were hearing to emergency orders, and we defined those online and in letters to the bar as any case that didn't have any temporary orders in it. So we wanted to resolve those matters before they became a true emergency, and we saw everyone in ex parte. We were hearing ex parte restraining orders still. We continue to hear writs of habeas corpus where children weren't being returned pursuant to court orders, and we certainly had a lot more of those at the beginning of this process. A lot of parents weren't turning their children over because they were afraid of COVID, but those, I haven't had very many of those recently at all. I think parents are getting on board with how the court is at least interpreting all the orders that have come down about following parenting plans, and children should still be exchanged. We continue to run ex parte 5 days a week in the afternoons, and I guess afternoons in the courtroom, because as most of you, I think, have figured out, we do have an email box that we set up fairly quickly for pleadings to be emailed in. A lot of people were started to email their domestic violence protection order petitions in there, and we would sign those. We'll review those, sign those, then we would get them scanned and emailed back and get them over to law enforcement and file them for the parties as well. We were getting ex parte restraining orders in there. We would then set a hearing for later that day for parties to appear telephonically in ex parte. Some people still came in. I won't name those attorneys. One might be in this courtroom. But we tried to do as much telephonically as possible in order to really reduce the traffic at the courthouse, and to also reduce the amount of staff we had to have at the courthouse as well, because it creates an issue of safety and social distancing for us as well, in our chambers and our Family Law Center and all the other areas that we work in. So we actually, I mean, today alone in that email box, I think I've signed about 30 or 40 orders that have come through that. So I think a lot of people have started utilizing that. So we continue to run those dockets. And I want everyone just to stop and think for a minute, because I know it doesn't look like we're doing a lot, at least that's what I've heard. But every time I sign one of those orders, I have to open it, review it, sign it, scan it, send it to Amanda to then send it back to the parties. So for every order I review and sign, there's a lot of admin time that goes with that. So that has kept us really busy, and I think it's efficient for a lot of the parties and the attorneys, but it frankly is not efficient for the court, and so, but we've really tried to accommodate the parties with that. We've continued to have a lot of orders sent in through the ex parte mail. That filing fee has been waived, that ex parte presentment fee, and I would say daily we're getting about, downstairs at least this week, we've gotten at least, I would say 75 to 100 orders a day in that basket. We are turning those around fairly quickly, I would say within 24 hours. We have kept our DV dockets open. Those again had to look a little different because we couldn't bring the large crowds in, so we had to scramble to figure out how to do that. We've continued to do those telephonically. We do hope to move those to Zoom, but we were doing that 3 days a week. I think we're now down to 2 days a week, but we were for the most of this doing that 3 days a week. We would set the hearings at specific times. We would give numbers to call in at, and those were 3 full days a week. We continue to run juvenile dependency dockets on an emergency basis for a very long time, just emergency orders or shelter care orders. Then we slowly expanded that docket. I think that was the first docket we started doing Zoom hearings on as commissioners to see how that would go. We continue to run our guardianship hearings here. Again, we limited what we were hearing because we had to have people call in, and that's a whole different procedure. And again, the admin work that goes with printing everything off, filing everything, scanning it back, and getting it to the appropriate people. So we have stayed really busy here on campus. We've also stayed really busy off campus doing our civil commitment hearings, guardianship hearings. Some of those were conducted remotely as well. So we've stayed really busy. We have had our dockets open. They may have looked different. We might not have heard everything that we were previously hearing. We might have had to do things a little differently than before. But I would say within a couple of weeks, we did have everything up and running that we were going to have for that time. But that is what I was here to talk about as one of the commissioners that were here every week. So, I don't know if anyone has questions. Are we doing questions?
We're going to try to do that at the end.
Perfect.
Thank you. That takes us to kind of the redefined item on our agenda. And first I'm going to ask Judge Please to address. We've tried to, as the family law judges, stay in fairly close contact with each other, individually as well as through our JAs, and so we're trying to match up what we're doing so the council doesn't feel like they're being treated differently from one room to the other. But I'll ask Judge Please to address this topic for us.
Okay, let's see if you can all hear me. Everybody hear me? No? Yes? Okay, perfect. I've got kind of just a couple of things. I can't tell you since this all started, the judges, all the judicial officers, we've met regularly talking about what do we do, how do we handle things. Obviously, the criminal dockets were a real concern. But as time went on, Judge Fennessy and I both started to actually have a panic attack trying to figure out how to get back on moving forward with this, and everybody kept saying, oh, this might last till September, October. I think you're going to see this last all the way into next year. And so we were panicking on what to do because I felt like we were on a good roll of getting cases through the system and processing, trying cases, hearing things. And then everything came to a big screeching halt. And we kind of lumped in the beginning, domestic in with civil, and we kind of just kept it going along with that, just hearing the emergency. And then we decided we can start with the Zoom capabilities, and I love Zoom. It's hard for trials at times, but it's been working for us, especially for docket calls. And so in the future, I'm expecting that we'll still do Zoom hearings. We'll still have people can come into the courtroom. I'm one of the lucky ones. I think Judge Fennessy is too, because we have bigger courtrooms. So we changed a 75-person courtroom into a 25-person courtroom by marking social distancing. We still meet regularly, all of the judicial officers, thinking of things, sneeze glass, shower curtains, how can we do in-person court, especially once criminal comes back online. So we are doing stuff behind the scenes, trying to think of the easiest way. One of the things that we were also talking about is we are going to continue to take scanned documents, finalizing documents. It's a lot of paper for the court as far as if you're sending me all your finalization and you've got a parenting plan and child support and findings and decree and residential schedule. I mean, we're going through paper like crazy, which is a concern, but we also want to make it safe and process it. So we will still continue to do it. We're still in the COVID, safety measures. One of the other things we talked about, though, is I know there's a couple of judges that talked about sending in your exhibits for trial electronically. I'm not in favor of that at this point for me, and I think you're going to see it judge by judge. I still would like your notebooks. I like to hold them and feel them, and I know some of the judges said, no, just send them electronically. I already have 4 screens on my bench. I'm not in favor of a lot more screens because I am looking at court documents and my real time, and so I'm going to still ask that you bring the notebooks in. Your motions, still drop off your briefing for your motions. If it's a last-minute thing, we have been taking like a 2-page or 3-page reply electronically, but with the amount of paperwork, we obviously would like you to drop it off. One of the things, though, that we are going to talk about, Judge Price put out rules, etiquette rules on Zoom, and after having done some trials now on Zoom, there are a lot of etiquette. Even if you're muted, we can still see you. Please don't eat. Sit there and make a Jack and Coke while your hearing is going on, because we can see that. Definitely, please do not go into the restroom while we're on film. And I'm saying this because it's really happening at times. And so Judge Price came out with a list. I'm going to kind of make it a little bit simpler. All his rules are great. I think sometimes there's a long list, but it's just remember you're in court. Look appropriate, act appropriate because we can see you. Like somebody driving, and apparently must be just listening. I can't read the names, but I see you guys. The other thing is mask or no mask. People keep asking me, and I felt like watching TV and seeing that different health officials were back and forth. Wear a mask, don't wear a mask. We had talked to some of the county officials and said, well, if you're feeling sick, you should wear a mask. Well, I'm sorry, if you're feeling sick, stay home. Don't even come anywhere, even with a mask. Stay home. But we took the liberty to pass a rule that if you're in the back of the courtroom and you're not participating, you should wear a mask. And now the county has taken it on themselves that starting June 8th, everybody will wear a mask, coming in, coming out. We have been talking about it a lot because when you have someone in court testifying and they've got a mask covering their face, how do you judge credibility? It makes it very hard. I also don't know, no offense, but some lawyers may be sitting at counsel table with their tongue sticking out at me through the whole thing because they don't like my ruling, and I wouldn't be able to tell with a mask. And so I like no mask because I want to see the people, but I also have some fear of getting COVID. So right now you are going to be having to wear masks, and it's going to be, I think, a courtroom by courtroom, whether the judge actually wears them or if he's going to ask the witness to take them off. I think if it comes down to credibility and they're testifying at the witness stand, we might ask them. So that's where Zoom comes in. We can see them on Zoom and they don't have to wear a mask. That's awesome. One of the other things we talked about is what are we going to do, as we found out last Monday when the courthouse got closed because of riots, who would have thought in Spokane, how we deal with it and kind of respond to it. We have been getting everybody's email as possible as we can, but sometimes with the pro se's it's been really hard. I did ask the clerk's office when people are filing forms, please make sure you can verify their emails and their addresses. at least we can email and say, you know, your hearing got canceled, but it's reset. So if you can also make sure that we have every kind of contact information so we can let you know what's going on. Those were just some of the things that I thought of that kind of tell you how we're doing. We got a huge backlog, and we're really trying to get through them. I know one of the things I want to clarify, I did a training at the law school. A lot of you family law lawyers came, and it was said that I said I don't like family law. And I'm going to reiterate it, but I don't like it because it's sad. And that's one of the hardest parts of me doing family law is, you know, I can do a civil case. You know, everybody's got interest in the case, but it's not sad. Child rape cases, I did 11 of them last year. Those are sad. I didn't want to do them, but I did them. I don't want to do family law. Here's people who love each other, and now they're fighting in court. So I don't mind it. I'm doing it. It's just I try to keep the emotion out of it, and I've seen some sad cases. So I want you to know that's the only reason I don't, is it does invoke a lot of emotions that you feel bad for kids stuck between either two good parents or two bad parents or one of each. So that's why I want you to know that it's not the lawyers, it's just the cases are very sad. So I hope I cleared that up, and I think I've been trying to get through it and bring you guys in to work with us and try to communicate what the court's doing. So, yeah, not just Tennessee.
Thank you. Well, just kind of to wrap up at least our part and then encourage questions. There is a question on the chat, whether or not active participants can still take them off. And that just brings up for me that this is, as Commissioner Ressa mentioned, these are unprecedented times, and we're wading through lawyer-like language all the time. The governor is a lawyer. He has counsel that writes for him that are lawyers. The Supreme Court is full of lawyers. They're writing decisions or rules and emergency orders. We are writing emergency orders, and we're considering those from the perspective of judges that are looking at criminal cases, where there's a constitutional right to confront the witnesses against you, where there's a right to counsel at all stages. And does that mean in-presence counsel, and how can we accommodate social distancing in those circumstances? And yes, it involves family law cases. And so we're trying to stay up and stay together on all of these things. I think that, as Judge Please mentioned, we locally have said we can control our courtrooms, and everybody recognizes wearing masks is a benefit to the other people in your space. We share the airspace here. We can maintain social distancing. We believe that it's better to have people in the back, not actively participating in a hearing, to have masks on. And we're going to try to enforce that everywhere, in all the courtrooms. Then we have active participants in the courtroom, those at counsel table. In a family law setting, it's easier because we can maintain social distancing. Typically, we have one client and one lawyer on each side. In my courtroom, there's room for social distancing. We have also added the plexiglass barriers to counsel table, and we've moved the podium up so that we think we have social distancing to the best that we can everywhere. So yes, if you're an active participant, you can take your mask off in the well. The county commissioners have determined and issued an order that beginning June 8th, we all will be wearing masks. As Judge Please indicated, we have questions in that regard. Are we covered by the commissioner's standards because of the positions that we hold? They address employees. They're concerned about some L&I liability. They're concerned about safety. They're concerned about public safety. So we have a lot of issues. None of you all are our employees or their employees. So we still have a ways to go as we wind our way through these. Judges, I think, as Judge Please indicated, would prefer not to have to wear a mask all day long and articulate objections or rulings on objections and rulings on evidence and make decisions, because sometimes it's hard for us to communicate only through voice. We communicate through tone, which is deadened by the mask. We communicate with facial expressions, which are masked. So we have a ways to go in that regard. We're all going to get through it, and we ask your participation and assistance as we make those choices. Those are the rules that we're operating under right now. There may be modifications as we move forward. So yes, to the question online, we can, as active participants, have the masks off. I appreciate Commissioner Ressa saying she never wants to go back, and I think she added, at least not completely to where we were, because we have learned things. We are getting better, and we have to take this as an opportunity to get better. But I will say, maybe not go all the way back, but boy, I want to go a long way back, because I miss having people around. I miss the collegiality, the opportunity to share a story about a weekend, the opportunity to know who's coming in, and the opportunity to participate in one another's lives. Yes, we're getting better at this, and we will continue to do that. And I very much appreciate Judge Belkengren's access to justice plea. She asked me, should I not say that because it's different than maybe you feel, Judge Tennessee. And we're all judicial officers. We all have different experiences. We all have different preferences. I absolutely respect and appreciate that there is an access to justice improvement if people don't have to traipse in here and give up a whole day. I also cannot get rid of, for myself, the idea that if my opponent is going to be in front of the judge or a witness live, I will not give up my right to be there. And that's maybe old-fashioned, and maybe I need to get rid of it. But I really believe that there's a lot of human communication and connection that goes on in person. So I don't want to dictate, and that goes back to my comments earlier about the difficulty running a Zoom hearing is that the host needs to be much more controlling of the participants, and that's not always beneficial to a free flow of information, because someone may have an observation where they can make an objection that might not come through on a Zoom call where you've got 4 different or 5 different or even more different participants. So there's some learning curves that have to go on there. But I think you're going to find in each courtroom there will be slight modifications. I want to point out, just technologically, we're keeping up. We're doing better and better and better. In this courtroom, you can see, those of you participating in Zoom, we have the clerk's computer hooked up to a camera that is connected to live Zoom so that people can see counsel table and the podium. We have the court's bench top connected to a camera so that you can see the judicial officer, and we have a laptop connected to a third camera so that you can see the witness chair. So we are doing the best that we can to make that access to justice very broad, and everyone can hear, everyone can participate, and I am very much in favor of people that wish to participate in hearings through Zoom are encouraged and welcome to do that. It takes some planning. If you're going to have a witness that has an exhibit that you want to admit, and you're going to be here, or you're going to be in your office and the witness is going to be home or in their office, it takes some pre-planning. That witness has to have this document well before the witness is sworn, and you have to have practiced perhaps your presentation. So those are things that you have to think about. As Judge Please mentioned, we have had trips out for cigarettes. We have had trips to other parts of people's homes that we didn't deserve to be in. And that's an instruction we don't have to give to counsel, but counsel has to remember to give it to their clients, and maybe even take the liberty of sharing it with a pro se litigant on the other side of the case, for professionalism, because we do want to maintain the decorum and the sanctity of our hearings. It's important that the solemnity of our presentation and the solemnity of your presentations to us is still very, very important, and we don't want to lose that as we make these advances in communication technologies and styles. Those are the things that I had to offer. I don't know, Judge McKay, was there anything that you wanted to bring to the court or to the family law members? I know we appreciate your attendance, and
I will make my way to the podium. I was not, excuse me, can you all hear me?
Yes.
Somebody give a thumbs up or a clap for me, or give me the thumbs up from the Zoom. But I was not anticipating having anything to say, but I am in a position of being assistant presiding, so I have sat in on a lot of the meetings that have gone on with regards to processing forward in how the court is doing things. One of the major questions that we get is, can we have consistency across the board in the courthouse? I will tell you, yes, we can. There's just 20 different positions. There are some areas where we can be consistent, and we are attempting to gain that through the masks. However, there are different types of hearings. So if you make one rule, the court doesn't have just one type of hearing. We have trials, we have hearings on the pleadings, we have live hearings, we have pro se participants that are perhaps benefiting from seeing people versus us just reading something and doing first a telephone hearing, now Zoom hearings. So while we would like to be consistent, we still have to provide access and are doing the best that we can. I will second that. I do know moving forward, again, we would like to think this is going away. It isn't anytime soon. I did see, and I don't know if somebody's going to be addressing it because I'm going to get back to my chair in the corner and give this back to the experts. But one of the questions that I did see is, are we going to be continuing family law roll call, domestic violence roll call in a remote fashion? And yes, we are going to attempt to do that because, frankly, we can't have you all in a courtroom. It doesn't work that way. The cattle calls, the thunder dockets, we can't social distance and do those. So the attempts that we are making to have those done by Zoom or remotely are based upon the circumstances that we have. If those work well, they may stay around for longer than perhaps Judge Fennessy may want them to. But we are still working through this. I'm not sure we can give a lot of definitive answers, but know that we are treating this pandemic seriously and the requirements of social distancing. My courtroom used to hold about 12 people, it now holds 3. That doesn't include staff. So mine is not the one that would be used for these large hearings, but Zoom hearings will work if you can get the operator, the host, me, to make it happen correctly. I'm still a work in progress. So thank you for your patience. But I'm going to turn it back for some of those questions to what's actually happening moving forward in the family law, domestic violence, and trial departments. I make distinctions between commissioner dockets and the trial dockets. I probably shouldn't, but they are different. So with that, thank you.
thank you. We just did receive a question, and the question is, moving forward, what if one party wants to be on Zoom, but the other wants to be in the courtroom? Is there a plan to balance that still? And I'll just speak from my experience, and I'll invite any of the other judicial officers to share theirs. Absolutely. We will accommodate attendance and appearance at our hearings as in whatever fashion you prefer. We are continuing, and we don't yet have to address what what Judge McKay just raised, because we haven't had those removed yet. We are still under the stay home, stay healthy, or go back to work part-time, or whatever it is. But our courtrooms are still limited, and we are going to continue to provide this access under the governor's rules and under the Supreme Court guidelines. If and when those change, we will modify our presentation styles, but I think all judicial officers in Spokane County are more than willing to have one party present and one party via Zoom, if that's how you want to, and you can present witnesses via Zoom, you can present witnesses live. But we are going to insist on social distancing. We are going to insist on the CDC's guidelines for masks and all of the things that are present in our society today that are different. And I think that some judicial officers are going to share that my courtroom space doesn't accommodate more than one person or 3 people. The commissioner courtroom maybe doesn't make that type of hearing possible. So you're going to find certain discretionary differences. But for overall, we're trying to be consistent to say, we want you to have access to justice. We want your clients to have access to justice, and we're going to accommodate that the best that we can.
Yeah. In regards to the commissioner dockets and one person participating by Zoom and one in person, the commissioners are trying to come to a consensus on that too. We do want to all be on the same page. I've had hearings recently where we've told people to appear by Zoom and we still have somebody in the courtroom. And right now I don't know that I have the authority to tell someone not to be in the courtroom, but I have had the opposing attorney who's appeared by Zoom ask if they're allowed to appear in person as well because they feel it's an unfair advantage. I've had that come up a few times. I do make the attorney in the courtroom also use Zoom. It's still not fair yet because unlike the judges' courtrooms who have these big TVs on the wall, we don't have our TVs up yet. We've asked for TVs, and I know we're getting some for all the courtrooms so that if one person is remote and appearing by Zoom and one attorney is sitting at counsel tables appearing by Zoom, we can all see the same thing on the screen. So it is really important, and we need to start enforcing it across the board, that the attorney also needs to be there on video as well. We all need to be seeing the same thing. So we're trying to get that set up so it is equal across the board, because I have had attorneys before a hearing say they think it's prejudicial to them to be in their office on Zoom while the other attorney is in my courtroom. And as a practitioner, I probably would have felt that same way. I don't know that I can tell people not to come into the courtroom yet, if they can be socially distanced, so I've let people come into the courtroom. We do need to have further discussions on that if we're going to come to a consensus and have it across the board, because I understand that. I assured the attorney that that's not, wasn't going to prejudice him, and having read the case, I knew it wasn't going to prejudice him, but I can see why that would still be concerning. So, Commissioner Ressa, you might want to address some of that too. The commissioners have had a lot of conversations about this, but it still keeps being an issue.
Yeah, we look forward to having the technology in our courtrooms as well, but remember the size of them, and that will become an issue if lots of people start coming. And the commissioners are employees. The governor's proclamation says all employees in their workspace beginning June 8th will wear a mask. So if I'm in the courtroom with my clerk and with you, I will have to be wearing a mask if I'm following the governor's proclamation. If you don't come and go on the hearing by Zoom, where I can also be by Zoom from my chambers where I'm sitting now, and we can all participate equally, we will be able to communicate better because we'll be able to see each other's faces, hear inflections, get tone. So you will create a problem for your commissioners by showing up right now until we have the better technology, or until it's lifted that we aren't employees wearing masks as the bench trying to talk to people and trying to get them to understand a ruling. We sit in a different position than the elected officials. So that's why you unfortunately are not going to likely get 20 courtrooms that look exactly the same on this issue, because there just isn't a way right now to define us differently. So we hope you will, if it's a technology issue, please talk to somebody about getting training. We're willing and welcoming more trainings if we need them. If it's an access issue, let's talk about the different places that access can occur. If it's, I just need to be in the courtroom, then, I'm not sure I'm going to be able to really understand that reasoning. But we need to have equal hearings, and we all need to be seeing and hearing the same things. And the new added wrinkle on Monday is the mask that employees will have to wear, which I am one of.
We have another question. When will all contempt hearings resume? I have a couple of cases of alleged contempt without children, and there's a material hardship. So there's a question, again, for the commissioners. Commissioner Swenson?
I don't know if this has been approved yet, but tentatively, the commissioners were opening their family law dockets up fully as of June 15th. So we have been slowly expanding, all the commissioners are back on their regular days, and as of June 15th, we should be hearing all matters across the board on family law. Still by Zoom, and we will be in masks.
So we hope to have those announcements out next week. They just need to be approved through different channels, and they're going through those channels now.
Next question, domestic case scheduling orders are being treated differently than the civil case schedule orders. Are the domestic orders for trial dates set in March, April, May, or June being reissued to after June 1 like the civil case schedule orders? If not, why not? And I'll answer from my court, and then Judge Please can answer from hers. I think they have been all the way along. We've been issuing new case scheduling orders in our family law cases. Some we reissued in March, setting cases because we thought they would be heard in April or May. Those obviously have not gone forward, but there have been new case scheduling orders issued in those. I believe that the last bench trial that I had in a family law case was March 16th and 17th, because we hadn't been, the stay home, stay healthy hadn't been mandated yet, and so I was able to continue because that case got started, and we have recommenced bench trials effective May 11th. So we were able to come back to live hearings May 5th, and we ironed out some additional issues, and now we've been trying cases since May 11th. And it should be that all case schedule orders in those family law cases have been reissued. Judge, please, do you have a different?
No, that was exactly it, but if we missed some, because we sent so many scheduling orders out, contacted JA right away, because I can't say we couldn't have missed some.
Any other questions? We did have a couple of write-in questions. One was, what will docket call look like? I think we're continuing, as indicated. I am...
Okay. This is the vice president.
Oh, I can't do that from here.
Technical difficulties, no. The device turns off automatically in 29 seconds.
That's this, right?
28, 25.
As far as the docket calls, I guess I'm one of the few judicial officers that is considering and trying to schedule things. When we have, as Judge McKay is fond of saying, the thunder dockets, right now we have a lot of social distancing. We haven't had any where we've had too many people in this courtroom. That obviously changes from courtroom to courtroom. But we continue to have some participants by Zoom and some participants who are live. I'm going to have to spend more time considering whether it's equal for someone to be present on the Zoom and someone else to be present by video when both parties have a choice. I haven't honestly considered that, and I'm unlikely to send someone who's here to the back of the courtroom to go participate by Zoom, or out in the hallway to participate by Zoom. So that comes as a new question for me. But I also think that when we have crowded dockets, we as judicial officers try to come up with creative ways to resolve that. And so one of the ways that we've started to do it is give individual time. So we can have a certain group, perhaps 3 or 4 cases that are set on a pretrial conference, or for a pretrial conference come in at 11, and 3 or 4 different come in at 11:30. Or for a while we were running 10 through noon so that we could achieve social distancing and achieve social space. So as those things occur, we're trying to take advantage of the opportunities to exercise that discretion. Judge McKay?
I'm going to step to the podium and get a little bit of information. Part of the question about the docket call, I think, probably applies to what I just barely referenced of the family law commissioner docket, the hearing slots, as well as domestic violence. Although I'm not sure that the family law attorneys deal with as the same level or amount of domestic violence hearings as they do family law. The actual docket call itself, where all of the attorneys and the pro se litigants are all in one courtroom and a commissioner takes the bench and calls roll call, won't be happening, and won't be happening until we can get beyond social distancing. So you all using your common sense will know that social distancing is not ending anytime soon. Those will be a call-in procedure. We're working on that from an efficiency standpoint. So my point of bringing this up is to say, those of you who relied on going to docket call to then, for the first time, chat with opposing counsel to see whether you're really going to a hearing or not, or whether you're going to hearing on everything versus perhaps just one issue, those days are probably over. We don't have the ability under today's parameters of social distancing and mask wearing and all of that to have that. That, I think, goes back to what Judge Belkengren refers to of you may have to rethink how you practice, whether it was just by rote habit or whether it was just ease or you just couldn't get a hold of somebody. We don't have the ability to have bench conferences before hearings are scheduled. So we are working on a process of figuring that out. It certainly is still a work in progress at this point in time, but it will be still a call-in for those family law hearings given a slot, and then you either take that slot or you try to figure out, and we are trying to figure out the process of having bench conferences for those that don't fit within the slot given, as you would if you were down here. Not a good answer, I think, for those of you listening to this going, well, yeah, but how does that tell me how I do this? We're working on that. But again, I want to reiterate, you may have to change how you practice and have conversations with a pro se that you didn't have to have before because you could just come on down to the courthouse and have it. You're going to have to change that habit. You're going to have to talk to an attorney that perhaps you don't get along with very well because we don't have the ability to do it the way we used to do it. We're trying, but I'm not sure that we're ever going to get back to that style, for lack of a better term. I do want to make one other thing. Please be cognizant of, we're using FDR Gold for these hearings. Masks and FDR Gold don't mix very well. They don't mix well with court reporters either that are in the actual trial dockets, but the commissioners are using FDR Gold. So for hearing purposes, that is still, again, a problem with masks. I think that Zoom hearings, you're probably going to get a better record than you do if you're standing in a courtroom participating with a mask on, which may or may not be a requirement in certain courts or not in others. With that said, I'll step back again.
Well, I think those are very good observations. I appreciate that, Judge McKay, and it harkens for me back to one of the tenets of a educational piece that I attended early on in this process, and that was to remind us as judicial officers, we have a role in this process. The pandemic has not changed that role. I can't do the job of counsel. That's counsel's job. And so if you need to have clearance of issues, if you have to talk to somebody before a hearing, I can't manage that for you. You still have to manage that. You may have to change your practice in light of everything else, and we certainly have had to change ours.
I want to say one thing.
And Judge, I have to answer a question too when Commissioner Swenomson's done.
I want to let people know who are at their offices doing Zoom hearings that just because the attorney's in the courtroom, the commissioner is not always taking the bench during those Zoom hearings. I did half of my Zoom hearings yesterday out of the Family Law Center in the back in a conference room by myself. The clerk was in the courtroom, an attorney may have been in the courtroom, or both attorneys may have been in their offices. So just because an attorney was at the courthouse doesn't mean I even saw their face except for by Zoom. So think about that as well.
And you can always ask us if you think that we're in the courtroom and the other attorney is there, you know, what is happening, so we can explain the procedure. And my certain comment about having the hearings be equitable and equal do not necessarily relate to docket call, and those can be maybe some different considerations. I challenge you to find another county in the state of Washington that did a docket call like Spokane. You won't find one. And so it's probably not the best practice. And I just encourage you to go look at what other counties are doing and how they manage family law motions, and see if we can pick the best parts of those processes and put them into our new and improved process for docket calls. And my anecdotal support, and as I see it on the chat as well, is that that is a preferred change for a lot of the bar. I don't know if it's a preferred change for the pro ses, but it seems to be a preferred change for most of the bar. One other announcement that I think is official, so we need to make sure people start getting them where we don't have these instructions out yet. They'll be out next week as well, is that the room for X party will be changing to 202 starting on June 15th. So we'll have signage and you won't get lost, but just to be, we need that extra space because that's not a place we can control or even really anticipate what crowd will appear, and 304 just doesn't have the space for it. We don't want people waiting in the hall, and we don't want it to add stress outside of 306 and Judge Fennessy's courtroom. So the physical space temporarily for X party will be moving to the second floor starting that week of the 15th as well.
So the next question was, what about dates that were stayed, such as disclosure of witnesses, discovery deadlines, et cetera, but the scheduled trial date is outside of the March to June reissuance time frame? Again, for me, that's a case-by-case analysis. We are doing the best that we can to keep up with that. If it creates problems that counsel cannot work through, it ought to be brought to the judicial officer assigned or to the commissioner, and we should be able to work through those individually. But we're trying to reissue case schedules that would probably, in most cases, contain new deadlines as well. So I don't really see that as a significant problem, hopefully. There's an observation that a Zoom station in the county law library might be a place to hold Zoom meetings in the courthouse. I think that's a good observation. Judge McKay?
County Law Library is still closed. I don't know when it's going to open, but that's a good observation.
Yeah, so there are some actual difficulties with that. If the county law library is still closed, how do we get a phone line, who pays for the phone line, all of those issues, the camera. So but it's a topic worth exploring, I think I would say, for the judicial officers. Earlier it was suggested that attorneys can communicate with clients via a private Zoom chat during hearings if they are both appearing separately via Zoom. The question is, aren't those communications accessible and can be viewed as well as downloaded by the court as the host of the Zoom meeting? And if so, how does that impact the attorney-client privilege? And again, I'm not the Zoom king, but I can tell you there are breakout rooms that are different than waiting rooms. The waiting room is where you enter when you first come into the Zoom portal, if you will, and then you have to be admitted to the hearing by the host. But there are private breakout rooms, and those breakout rooms, I can't say that they can or cannot be monitored by the court. I don't think so. And I can tell you the court has no interest in monitoring those, and likely no time. So I don't see that that's an impediment to the breakout room usage, and I don't see it as a violation of the attorney-client privilege, because again, it should be the host or the co-host. Unlike Judge McKay, I'm not the host of my meetings. my judicial assistant is. And so I have certain executive power here on the bench, but for the most part, Mr. Shaw will be assigning individuals to breakout rooms. We'll have record of that. We'll have record of participants in breakout rooms and how long they're there. That's the more practical difficulty for me, is to know when counsel and their client has completed their discussion so that they can rejoin the hearing and we can recommence.
I'm not aware of any way of downloading any of that information. So I know when we set up our accounts, we didn't set them up to record anything from Zoom. So if someone knows that Zoom can do that, I'm certainly not aware that we are capable of doing it, or if it was an account issue, we didn't sign up for that.
Another question about whether or not we can notify counsel about or be put to the test of choosing between in-person or Zoom attendance at a hearing, because it's difficult to explain to a client if the other lawyer is present or the other party is present and they're not. Again, on this docket, for my hearings, I'm not inclined to insert myself in that choice. I feel like we've made everything available that we can make available, and I don't want to dictate or have one party dictate to the other party how they're going to exercise their rights. On the commissioner's dockets, it may be entirely different, and the commissioners, I think, have fairly and appropriately articulated their reasoning for that, and so until further notice, it sounds like commissioner attendance is going to be by Zoom, and that's because it's required by the social distancing requirements, and it's necessary. Otherwise, I don't see how I'm going to have one side say, I'm going to be there by Zoom. That limits the other side's ability to be here in person, or vice versa. And I'm not inclined. I'll invite any other judicial officers that are going to come up. If in your courtroom it's going to be only way to participate in a hearing on the family law docket is by Zoom, I don't think that's a present requirement. But I don't speak for everyone. If ex parte is moving to 202, will guardianship family law stay there or move? Presently,
I wrote an answer for her, so hopefully she can just read that since the hearings are by Zoom, they're by Zoom, they're by either video or phone. Those are how those motion hearings are happening right now. So you don't need to be worried about where they're happening, and that will be fluid as we pick out the new courtrooms. And when we have in person again, we will definitely be telling you where. So by phone or by Zoom, you'll be calling into your guardianship or your family law motion hearing.
I believe that covers all the questions that we have received. Are there any new questions? Mr. Dudley.
Question I have is two different topic areas. One is the protocols for the Zoom trials. I've recently done a trial where the attorney and their client appeared by Zoom. When I'm cross-examining my opposing party, I can tell just from looking down in the communication that the attorney is giving information to their client to how to answer. And so I don't know how, if we're going to have the attorney and their client both on Zoom, how we're going to be able to monitor and control the lawyer effectively giving testimony to their client, which they wouldn't be able to do if they were in person.
I find myself in this position on the bench a lot, and that is, if you can stand there and tell me I know that the lawyer's there and feeding the client information, then you know to bring that to the attention of the judicial officer, and there will need to be steps taken at that time. And I'll throw it back in your lap. Absolutely, it happens in the courtroom all the time. I'm sitting here, and You or another counsel is reading from the prepared plan and saying, asking yes or no questions of his or her witness. It happens all the time. If it's objectionable, then it needs to be objected to. If it's not objectionable, then it's your trial. I'm not going to insert myself.
Okay.
So I think that we can control that. I think that it's controllable by lawyers. You are the producers of this play. If you don't like the camera angle, if you don't like the way it's being portrayed, raise it. The judicial officer will have to make a decision, and we'll have to go forward from that perspective.
And my other question is, I think Judge McKay was starting to touch on it with this issue of we're not going to meet pro se's anymore. So one of the things I had is, if I can file a motion, set your hearing, you have no response from the pro se. And then they might show up, they might not show up. But if we're going to be calling it in 2 days prior to the hearing with no response from a pro se, we have no contact information for the pro se. So do we just send in our motion status sheet with one side and the commissioner decides what happens at the time? We don't even get a hearing slot because it's not like we can then just, the person doesn't show up, we go to ex parte, get our relief. So what is the mechanism going to be for when we get no response from a pro se but we still have to try to proceed with our case?
I appreciate that, and I'm going to invite the commissioners to respond.
So we've had that a lot actually already. We set the hearing time and we end up having the bench conference during the hearing time.
Well, it's not just the bench conference issue, it's if they don't show up, if they don't respond at all.
Right.
So you're just gonna set the hearing, if we send it in, you set the hearing for the half hour, 45 minutes.
You have no contact information, an email, a phone number. I mean, I haven't had that. We've had zero contact information for the other party.
Well, if I have a pro se litigant who doesn't respond, and I have nothing for them other than when they've been served, of course.
That is a different issue that we have to figure out. We haven't had that discussion.
Just make sure your joint status report is very clear about that. You can put your efforts to give notice, or you're going to have to certainly prove that the person's been served, but efforts to contact about the hearing, et cetera. Please also, thanks for the reminder, a good time to make sure you check your notice of hearings that you're sending out, that it needs to have Zoom information on it, or at least the call-in procedure, not the Zoom information, but the call-in procedure. Because if you just tell them to show up at a courtroom at 8:30, that's not going to be proper notice. So please check all your notices that are going out so that you are giving people the right notice. Matt, I think what our plan is, and that's a good thing to ask Amanda, if it's clear on your status sheet that that's the problem, we will set it, and then probably just not set it for the full 45 minutes and maybe set 2 or 3 in that time frame to address, if they do appear, when is it going to be reset, and make sure they know to respond.
How do you ensure the witness doesn't have notes to refer to? Again, I have the same observation. I think counsel, if you're concerned that a witness has notes, ask them that question. And if
Yeah. Yeah.
there we go. If you are convinced as counsel they have notes, you ask them that question, and then depending on their response, you move forward. And that should be brought to the judicial officer's attention, and the judicial officer will have to make a decision. So that's the best I can do on that topic.
Unless I got you socks.
Okay, anyone else?
Take care of your bag.
I don't know who's not muted. I can't tell.
I have a question.
Sure, Mr. Lee, go ahead.
Thank you. I tried to set a hearing for contempt. Of course, you have an order to show cause, and sent it in first with the through the commissionersorder.org, and it was kicked back, said to go to ex parte. So I did it that way. But as you know, you can't set it until you have the order to show cause, and I have to figure out how many days in order to set the hearing. But if I don't have it back on a relatively short period of time, I don't know when to set the hearing. And so is there a way we can kind of expedite that? It seems to me that going through the commissioner's order would have been the easiest way, the most expeditious way.
I sign order to show causes out of that email box all the time. So I know I sent one back to you a few weeks ago because it wasn't meeting the definition of what we were hearing. So if that's the reason I'm not going to hear that, you need to send that through the mail-in box and hope that we're hearing those matters by then. But I think I signed 4 or 5 today, order to show causes that were in that email box. That is the best way to do it. We're not going to file your motion. We're not going to file your declaration. All I'll print out is the order to show cause. I will put the date in that. I will get it signed, and I scan that back. I did that a lot today.
Good, thank you.
I guess maybe one final question, then we'll wrap up. Question is there anything that hasn't already been addressed that the bench, the judicial officers, would like to talk to the attorneys about to help in the current and future processes for the court? I guess my only observation is to make sure that, to the best of your ability, you keep up with the technological changes as well. Camera angle, internet speed, all of those practical issues are issues. And aside from that, we're all on a learning curve. It's a steep learning curve, and we are trying our best to take advantage of the things that we can. And if you learn something that you can share with us all, we're welcome to that, and we appreciate it. And if there are things that we observe, we'll try to share. That was the purpose of this call. I think as we set this, we anticipated that we would at least consider doing another one in 2 or 3 weeks if this circumstance continues. So please stay tuned. There may be additional editions of this as well. Mr. Dudley?
I apologize. This is probably going to be a Commissioner Swenson question to answer. One of the things we come up with is the motion to exceed page limits, which I know Commissioner Swenson's been so enjoying us bypassing that and reading things, as well as then the motion, say, for a teenager's declaration. We would have to go to ex parte, give notice, and then ask the commissioner to decide whether to do it. That's not available to us now, we're told. So is there a process where that's coming back? And I see Commissioner Swenson nodding her head.
Commissioner Ressa is joining.
Yes. Bench conferences are coming back. We're working that through the process. They're coming back in a different way than you've seen them before. We're working on the call-in procedure. So bench conferences are coming back, and that would be an issue for a bench conference or an ex parte. Ex parte will slowly start to expand as well, but those issues are coming back. Ex parte hours won't be full-time still, but it will come back with the bench conferences or with ex parte hours. I don't think the commissioners have specifically talked about the exceeding the page limits, but with ex parte slowly opening, I suspect that would occur as well. So yes, those will be back.
All right, Mr. Goebel asked, should show cause orders reference the Zoom requirement?
Yes.
Or incorporate by reference the family law note for hearing with the Zoom content? Yes.
Yes, the answer is yes. Every single one that I did today, I looked up who the commissioner was, and I put their Zoom ID number right on the order to show cause, and then also wrote in, please, you'll have to follow the call-in procedures on the family law Superior Court website, 2 days before. So if you guys could put all that information on there for me, that would be great, with how the call-in is, the email in, or however the procedure is with that commissioner's Zoom ID number, because that gives the other party, whether pro se or an attorney, a lot more information ahead of time. So I've been handwriting that in, so I'd love that information to be on your order to show causes.
I don't know if everyone will write it in. So if you don't, you'll get to the hearing and you'll get told you didn't have proper notice if it only said show up at 8:30 on a Friday, for example. So please try to incorporate that. We, as you just heard Commissioner Swinham said, we are trying to be as accommodating as possible with all these new changes and new procedures. We are hoping that it looks like we're accommodating these new ways of doing business, but eventually you really have to take that on and make sure your notices are adequate and accurate.
So are we still scanning and sending all of the material along with your motion status form to the commissioner?
The new instructions that you'll get will ask you not to scan things that have been filed unless they've only filed in the last 5 days, because we were getting emails that are just enormous. So if it's been in the file for at least 5 days, then we'll be able to see that electronically and you don't need to scan it to us. If it's less than 5 days, we still aren't for sure going to be able to see it electronically. So for now, that's the proposed new family law. As we open up all the motions, we'll give you that instruction of, we're still debating on whether it's 5 or 3. So watch for that next week.
Okay, thank you.
Good afternoon, Your Honors. This is Eric Levitt. I have a proposed simple solution for the first question that Mr. Dudley posed regarding attorneys being able to chat with their clients by Zoom during testimony. I believe the court can make or control the ability to chat by making parties co-hosts. And so if it becomes a standard practice to remove the party that's testifying and the attorney that's questioning him as co-hosts during testimony, I think that would just take that out of the realm of possibility and prevent attorneys from needing to make objections based on suspicion rather than demonstrative evidence.
Thank you, Mr. Levitt. I'm going to have to digest that a little bit before I start thinking about making more people co-hosts of a procedure that is the court's portal. But I'm not saying no, I'm just saying I don't know. But thank you for that observation. Judge McKay?
And I'm only standing here kind of as a closing to pass on to everyone. I am kind of trying to assist the commissioners and the rewriting of some of these policies as we come back. I'm at the back of the room going, oh, I didn't think about that. Show causes. Okay, we need to think about that. Oh, didn't think about how we deal with a litigant who we don't have any information on. All of these things are occurring as we go through. So again, I just ask for your patience, point these things out. Communication, as Commissioner Ressa and Commissioner Swedenson said, as you send your status sheets in, give that information so we aren't just wondering what happened. But again, we're doing the best we can, but I'll be honest with you, there are a lot of moving pieces to this court system down here, and to remember every single one of them, to address them all adequately as they apply to each one of you. If you can figure out how to do that, come on down. I am more than happy to have you take a shot at it. I don't mean to be facetious, but I just ask for patience because we are doing the best that we can to address all of these issues, and we do not intend to slight anybody, forget anybody, make light of any of the issues that might be coming up that we need to address. Again, just asking for patience in something that I never thought we'd have to do. Me having to use a computer for Zoom was never anything I thought that I would have to do. Guess what? I'm having to figure it out. Thank you. Yes, yes, yes. Absolutely. We appreciate the suggestions that you may have, any solutions you may have. Mr. Levitt, you pointing that out, I don't think stops the sneaky lawyer and attorney from using their cell phones on the outside. So we can't control everything. We do have to rely on folks to be professional, to do it the right way, to not cheat the system, but we can't fix it all. So I can appreciate that. But any suggestions that you have, believe me, we are open to send them in whatever method we have. Amanda and Susan are about ready to cry based upon all of the changes that have been going on. So maybe not to them, but in some method where we can get that information would be appreciated.
Can I echo that to please not use the family law staff as your people to figure out how the court is resuming its operations. We are putting instructions on our website the minute we change them. We are sending them out to as many groups that have listservs. Amanda and Susan cannot answer 40 of the same question by email and by phone over and over and over again. They are extremely helpful. You are overwhelming them, and it needs to stop because the instructions are there. Please use them. And if there's a constant question that's the same for a lot of people, we'd love to answer that. But I would, I'd say the same for our GMP staff, for some of you who do that kind of work too. It doesn't seem when we get the questions that there was even an attempt to look at the website and get your question answered first. I know they're lovely to talk to and you probably miss them, but you can see how many of you there are, and it's too much because they're also trying to help us with the amount of changes that are going on here as well. So please limit your calls to things that have to be answered directly by them, and watch those emails to the court commissioner's box. They do not go to family law. Do not CC Amanda, do not CC Susan, just send it there. And if we are monitoring that box all day, and they aren't monitoring, so please don't include them in those extra emails. If you're like me, I've never gotten so many emails in my entire life, and it's really hard to manage them and it becomes overwhelming. So please just cut down on anything but the gratitude and thank you communications to them, and check the website first for instructions. That helps us know if we're doing well on our instructions too.
Thank you, everyone. I think we were at 61 on Zoom and 6 on YouTube at peak participation. So I appreciate everyone being here, everyone's attendance, and sharing their good ideas, and look forward to continuing to improve as we move forward. Thank you, everyone.